No supervisor is consulted, no infractions are cited, and no established procedures are observed. The officer is unaware that this unilateral directive is both unlawful and documented, specifically targeting an individual whose official standing surpasses that of everyone involved. Within a matter of weeks, this precise moment will become a key element in a civil rights litigation seeking $14 million. Before we proceed further, please indicate your geographical location in the comments section and ensure you've subscribed, as tomorrow's narrative is one you absolutely won't want to miss. The gentleman receiving the warning is Daniel Harper, a man of 52 years, a distinguished judge with 26 years of dedicated service within the legal framework. His authority is not derived from his physical presence or his demeanor. It stems from his judicial pronouncements, established legal precedents, and his deep institutional knowledge. Attorneys approach their preparations differently when they anticipate Harper presiding. Legal clerks meticulously re-examine their filings. Even seasoned prosecutors choose their words with extreme caution. On this particular afternoon, Harper is engaged in a routine action, approaching the courtroom entrance to ascend to the bench for a pre-scheduled proceeding. He reaches the secured portal. His case files are already in hand when a uniformed officer steps to the side, obstructing his path. "Hold up," the officer states. Harper halts, looks up, and waits. He is accustomed to security protocols. He offers no resistance, no rejoinders, no display of impatience. The officer's identification tag reads Mark Lewis, Courthouse Security, assigned to this particular section for close to 3 years. Lewis does not initially request Harper's identification. He does not seek clarification. He briefly assesses Harper and then gestures away from the entrance. "You can't proceed in there," Lewis declares. Harper blinks once. "That is courtroom number 3. He responds calmly. "I am scheduled to be inside." Lewis does not acknowledge this statement. "You need to step back," he insists. "This area is off limits." The precise wording is significant. Harper notes it immediately. Off limits to whom is not specified. He poses a simple question. Under what policy is this area restricted? Lewis exhales audibly through his nose. His posture becomes rigid. "Don't engage with me," he commands. We've encountered individuals attempting to gain unauthorized access to courtrooms. That assumption lands with quiet yet undeniable finality. Harper remains motionless. "I have official business inside," he asserts. "If there is an issue, you can verify my credentials." Lewis makes no move to verify. He does not summon a court clerk. He does not consult the official schedule posted mere 10 feet away. Instead, he crosses his arms. "You're not comprehending," he states. "I am instructing you to vacate this area." This is not Lewis's inaugural confrontation of this nature. Over the past 2 years, at least 3 informal grievances have been lodged by courthouse personnel, all involving attorneys or litigants of color, who described Lewis as dismissive, excessively confrontational, and prone to assuming unauthorized presence. None of those complaints advanced to a formal stage. They remained confined to hallway discussions and discreet email exchanges. However, a discernible pattern existed, and it is now manifesting once more. Harper lowers his voice, not from apprehension, but for clarity. "Officer," he states, "I am entering this courtroom to preside." Lewis emits a short, sharp, disbelieving laugh. "Preside," he repeats. "Sir, I have no idea who you believe you are, but you will not pass me." That laugh serves as the turning point. It is the juncture where misunderstanding solidifies into prejudice. Harper reaches inside his jacket and produces his identification. He does not brandish it. He holds it steadily, waiting. Lewis takes it, casts a cursory glance, then returns it without reading the designated title. "This changes nothing," Lewis declares. "You are still not authorized." Harper looks past Lewis towards the courtroom door. The session is slated to commence in mere minutes. He turns back. "Please contact your supervisor," he requests. "This can be rectified immediately." Lewis shakes his head. "I do not require a supervisor," he replies. "I am security. The decision is mine." This refusal is deliberate. It eliminates any possibility of oversight. Harper recognizes this immediately. Lewis takes a step closer, lowering his voice. "If you persist with this, I will have you barred from the courthouse," he warns. permanently, or for a significant duration. The word permanently is not supported by any policy Lewis possesses the authority to enforce. Harper is aware of this. Lewis either is not, or he simply disregards it. A court bailiff pauses nearby, sensing the escalating tension. Lewis notices this and angles his body to shield Harper from view, asserting control over the interaction. "Last warning," he states. "Step away from the door." Harper does not raise his voice. He does not engage in further argument. He asks one final question, measured and precise. "Are you officially issuing a ban at this precise moment?" "Yes," Lewis affirms without hesitation. That affirmation holds significance. Harper nods slowly. "Then I will document that you have done so," he states. Lewis scoffs. "Document whatever you deem appropriate." Harper steps back, not in resignation, but as a strategic maneuver. He understands the importance of preserving the moment exactly as it unfolds. He retrieves his mobile device, meticulously noting the time, the denial of entry, the refusal to verify, the unilateral imposition of a ban, every pertinent detail. Lewis observes, confident that the situation is resolved. He is mistaken because what he perceives as a routine exercise of authority is, in reality, a documented infraction, directed at the senior judge assigned to that very courtroom, an individual whose access he had no legal right to deny, and the system has just been activated. The official log would later record that the officer did not disengage after imposing the ban. On the contrary, he escalated the situation. Lewis watches as Daniel Harper retreats from the courtroom entrance and begins composing a message on his mobile device. This action irritates him. Documentation feels akin to defiance. Lewis adjusts his stance again, positioning his body to completely obstruct the doorway. "Put the phone away," Lewis commands. Harper does not immediately look up. He finishes the sentence he is typing, then lowers the device. "I am recording our interaction," he responds calmly. "You are not authorized to record security operations," Lewis snaps. "I told you to leave." Harper meets his gaze. "You told me I was banned," he states. "You did not specify my destination." The distinction is crucial, but Lewis fails to acknowledge it. He raises his voice just enough to attract notice without shouting. "Step away from the entrance now." A second officer down the corridor glances over. He does not intervene. He hesitates, then looks away. Lewis observes this. His tone hardens. "If you do not comply," he warns, "I will detain you for obstruction." That word, detain, carries more weight than the preceding statements. It redefines the encounter. Harper absorbs it without visible reaction, but the shift is not lost on him, nor is it lost on the court clerk who has ceased feigning disinterest. "I am not obstructing anything," Harper replies. "I am standing precisely where I am permitted to stand." Lewis steps closer. Not making physical contact, not yet. Close enough to diminish the available space, creating a palpable imbalance of power without being overtly aggressive. "You are not in a position to make that determination," he states. Harper exhales slowly. Years spent in courtrooms have trained him for this exact scenario. He carefully selects his words. "Officer," he states, "I have requested a supervisor. That request has not been honored." Lewis scoffs, as it is unnecessary. He reaches for his radio. "Dispatch," Lewis announces, pressing the activation button. "I have an uncooperative individual refusing to leave a restricted zone." The phrasing is intentional. It recharacterizes Harper's compliance as resistance. Harper hears this and remains silent. He is aware that the official record now includes a misrepresentation. He also understands that attempting to verbally correct it will be futile. A few feet away, a junior clerk whispers to a colleague. Another individual subtly raises a mobile phone, angling it downwards, not recording overtly, but prepared to do so. Lewis notices the phones, the hushed conversations, the focused attention. His posture stiffens further. "This is precisely what I'm referring to," he says, gesturing vaguely, causing a disruption. Harper responds evenly. "I have not raised my voice." "That is irrelevant," Lewis retorts. "You are making people feel uneasy." The justification echoes earlier phrasing Lewis has employed. A court officer passing through pauses briefly, observing the exchange with a frown. He does not step in, but his expression conveys recognition, not surprise. Lewis notices this again. He turns back to Harper. "Hands where I can see them," he commands. Harper complies immediately, raising them slightly, palms open. The gesture is instinctive, not born of fear. It is procedural. "There is no threat present," Harper states quietly. Lewis disregards the statement. "You are impeding court operations," he declares. "That is grounds for removal." Harper glances once more towards the courtroom door. The delay is now a reality. He is aware that the scheduled session time has elapsed. He also understands that the delay is being deliberately orchestrated. A voice interjects from the side. "Mark," a female clerk says carefully, "that courtroom is—" Lewis snaps his head towards her. "Stay out of this." The abruptness of the response sends a ripple of unease through the nearby staff. The clerk steps back. Her lips press together. She does not argue. She does not need to. The admonishment itself becomes part of the unfolding scene. Harper observes how quickly individuals retreat, how authority silences even those who perceive that something is amiss. Lewis lowers his voice again, leaning in just enough to be heard solely by Harper. "You should have simply walked away," he advises. "Now you are exacerbating the situation." Harper meets his gaze. "I did not make it worse," he replies. "You did when you issued a ban you lack the authority to enforce." Lewis's jaw tightens. For the first time, irritation edges towards palpable uncertainty. "You repeatedly state that," he says, "as if it carries significance." "It does," Harper asserts. Lewis straightens and keys his radio again. "I require a supervisor to confirm removal," he states. His tone suggests confirmation, not a request for consultation. The response crackles back indistinctly. Lewis listens, nodding once. "Understood," he replies. He looks back at Harper with a renewed sense of confidence. "You heard that?" he states. "This is proceeding." Harper remains silent. Silence in this context is a strategic choice. As the seconds tick by, the atmosphere intensifies. More individuals are observing now. Not openly, but sufficiently. A bailiff pauses near the doorway, his eyes darting between Lewis and Harper. His brow furrows slightly. He recognizes Harper's cadence, the manner in which he speaks, his posture. Something does not align with Lewis's narrative. The bailiff does not intervene at this point, but he also does not depart. Lewis notices the bailiff's hesitation. He shifts again, now exhibiting a defensive posture. "Sir," he says, his voice louder, "this is your final opportunity to depart voluntarily." "Voluntarily implies a choice," Harper counters. "You have already imposed a ban." Lewis opens his mouth to respond, then stops. It's a brief pause, barely a second, but it's the first instance of hesitation. He recovers quickly. "Then I will escort you out," he declares. He gestures towards the exit corridor. Harper does not move immediately. He looks at Lewis, then at the bailiff, then at the clerk who was previously rebuffed. He speaks clearly, not loudly. "I am requesting that this interaction be documented with complete accuracy," he states, "including your refusal to verify my credentials." Lewis laughs, but it is now a weaker sound. "Do you truly believe this will benefit you?" "I know it will," Harper replies. The bailiff shifts his weight. He steps closer, just one step. "Mark," he says cautiously. "Perhaps—" Lewis cuts him off. "I have this handled." The interruption clearly irritates him more than Harper ever did. He turns back sharply. "You're being removed," he states, as Lewis extends his hand not to grab. Not yet. His eyes briefly flick towards Harper's mobile phone, still visible in his hand. The screen illuminates for a moment. A name header flashes at the top of an email draft. Lewis does not read it entirely, but he notes the formatting, the subject line. His hand pauses for a mere fraction of a second. It is subtle, but it is present. Lewis retracts his hand slightly, regaining his composure. "What is that?" he asks, nodding towards the phone. "Documentation," Harper replies. Lewis squints. He looks again, this time for a longer duration. He says nothing. The bailiff leans closer, his eyes narrowing as well. Something has shifted. Not clarity, not understanding, but a dawning doubt. Lewis straightens abruptly, masking it. "We are concluded here," he states, his voice louder than necessary. "Move." Harper does not resist. He turns slowly, complying, but not before the bailiff's eyes flick back to the phone, lingering once more. The bailiff's expression transforms. He does not speak yet, but he does not look away either. And that is the precise moment the officer realizes this situation is no longer entirely within his command. Lewis remains silent. The pause stretches longer than it should, long enough for the radio static to dissipate, long enough for the nearby murmurs to cease, long enough for individuals to sense that a change has occurred, even if they do not yet comprehend its nature. Lewis's gaze remains fixed on the mobile phone in Daniel Harper's hand. Not on the screen itself, but on the header, the formatting, the subject line he had only half glimpsed earlier. He straightens slowly, as if the mere act of movement might reset the moment. "What is that?" Lewis asks again, this time more quietly. Harper does not respond immediately. He does not need to. He locks the phone and lowers it, maintaining a neutral posture. "It's a draft incident report," he states, time-stamped. Lewis swallows. "For whom?" Before Harper can answer, the bailiff steps forward. Just one step, sufficient to be noticed. "Mark," he says carefully, "who did you say this individual was?" Lewis bristles. "That is not pertinent." The bailiff does not recede. He looks at Harper now, truly looks at him. The familiar cadence, the restrained demeanor, the fact that he has not argued, only clarified. The bailiff glances at the courtroom schedule posted nearby, then back at Harper. He frowns. "Sir," the bailiff states, "may I see your identification?" Lewis opens his mouth to protest, then stops himself. The interruption feels different now, more precarious. Harper hands over the identification without a word. The bailiff reads it, not quickly, not casually. His eyes move line by line. When he reaches the title, he freezes. His shoulders stiffen. He looks up at Harper, then back at the ID, then over at Lewis. "Judge Harper," the bailiff states. The name lands softly, but it carries considerable weight. Lewis blinks once, then twice. "What?" The bailiff turns the ID slightly so Lewis can see it. He does not shove it. He does not exaggerate. He simply allows the text to be visible. Lewis leans in, despite himself. "Senior judge assigned to courtroom 3. The shift is immediate. Lewis's posture changes first. The squared shoulders drop slightly. His chin lifts, then lowers. The confidence drains from his stance before it even leaves his face. He begins, then stops. No one laughs, no one speaks. The silence confirms the truth more effectively than any explanation could. A clerk nearby exhales sharply, covering her mouth. Another officer stiffens, his eyes widening. Someone lowers a mobile phone they hadn't realized they were holding aloft. Lewis clears his throat. "Your Honor," he says, the words unfamiliar on his tongue. "There appears to have been a misunderstanding." Harper calmly retrieves his identification. "There was no misunderstanding," he replies. "There was an action." Lewis nods too readily. "Yes, sir. I mean, Judge, I did not realize you did not verify." Harper interrupts, his voice not raised, not accusatory. He states a fact. Lewis's hands shift at his sides. "Of course, that is normally how I would." "But you didn't," Harper states. Another pause, shorter this time, more potent. The bailiff steps in again, his voice now firm. "Judge Harper is scheduled to preside in courtroom 3, he states. "We are already behind schedule." Lewis turns towards the courtroom door he had been blocking moments before. He steps aside immediately, clearing the path. The movement is instinctive, corrective. "Please," Lewis requests, gesturing with an open hand. "Proceed." The command has transformed into a request. Harper does not move yet. He looks at Lewis steadily. "You issued a ban," he states. "Do you intend to withdraw it?" Lewis flushes. "Yes, immediately. That was incorrect." "Document that?" Harper asks. Lewis nods again. "Of course." A supervisor's voice comes through Lewis's radio, faint but audible. "Mark, what is your status?" Lewis hesitates for a fraction of a second. "I require a supervisor at courtroom 3, immediately," he states. The phrasing is different this time. Not defensive, not declarative, but controlled. Harper finally steps forward, passing Lewis without physical contact. As he does, the clerk who had been cut off earlier lowers her head slightly in acknowledgement. The bailiff opens the door. Lewis stands motionless, his gaze fixed forward, his jaw tight. The realization is settling in layers. Not merely that he was mistaken, but that he acted autonomously, that witnesses were present, that documentation exists, and that the individual he targeted holds a higher position in the hierarchy than anyone he answers to. The supervisor arrives moments later. He first assesses the postures, Lewis standing rigid, the bailiff at attention. Harper is already moving towards the bench. "What transpired?" the supervisor inquires. The bailiff answers before Lewis can. Judge Harper was denied access to his courtroom and was issued an unauthorized ban. The supervisor's expression hardens. He turns to Lewis. "Is that accurate?" Lewis nods once. "Yes." No excuses. None are offered. The supervisor exhales slowly. "We will discuss this after court," he states. It is not a threat. It does not need to be. Harper does not look back. He adjusts his papers, his focus directed at the matter at hand. The work continues. That, more than anything, underscores the shift. Authority does not linger. It proceeds. Lewis steps back, suddenly aware of every camera, every witness, every second of footage that has continued to roll. The record has already been established. By the conclusion of the afternoon, a formal incident report is filed. Before evening, courthouse administration is apprised, and by the following morning, the footage has reached desks it was never intended to reach. The system is now fully engaged. By the end of the day, the incident is no longer being handled informally. A written report is submitted by courthouse security. Timestamps are meticulously verified. The supervisor who responded outside courtroom 3 files a supplementary statement noting the unauthorized ban and the failure to adhere to access verification protocols. Administrative staff flag the body camera footage associated with the incident and secure it for thorough review. What began as a singular interaction has now escalated into an internal administrative matter. The following morning, the review process commences. Security leadership requests the complete footage from the initial contact through to the resolution. No segments, no edits. The audio is transcribed. Every directive issued by the officer is logged and cross-referenced with established courthouse security policy. The language used to justify the ban is compared against the actual authority granted to exterior patrol officers. The absence of supervisory approval is duly noted. So too is the failure to verify credentials prior to imposing a restriction. Statements are solicited. The bailiff provides a written account. The clerks who witnessed the exchange submit brief, factual summaries. Another officer confirms hearing the radio transmission describing an uncooperative individual and notes that the description did not align with his observations. Each statement is concise. None engage in speculation. The official record builds through consistency. Policy references are attached to the file. One section delineates the circumstances under which an individual may be restricted from courthouse access. Another specifies precisely who possesses the authority to enact such restrictions. A third details the requisite steps for verification when an individual claims official court business. In every instance, the actions documented from the footage fall outside the approved procedural framework. The chain of command proceeds upward. By midday, the report reaches courthouse administration. By the afternoon, it is forwarded to the county's risk management office. Legal counsel is alerted not due to an imminent lawsuit, but because the evidence of misconduct is undeniable. Infringements on civil liberties are evaluated based on actions, not solely on intention. Within 2 days, Officer Mark Lewis is suspended from active duty. This notification is a standard procedural step, not accompanied by any public declaration. His identification card is temporarily invalidated, and his assignments involving external patrols are reallocated. Within the department, the underlying reason is evident: an ongoing inquiry into behavior unbecoming of an officer and the improper use of official power. Lewis accepts the suspension without protest. He is directed to refrain from discussing the incident with his colleagues. His past training records are scrutinized. Previously unaddressed informal complaints, which had been dormant, are revisited in light of the available video evidence. The focus is on assessing whether a pattern of behavior exists, rather than merely asserting one. As this internal review progresses, a parallel process is initiated. Judge Daniel Harper formally lodges a complaint through the Judicial Oversight Body. The complaint is succinct, detailing specific dates, times, explicit statements made, and breaches of established regulations. It deliberately omits any personal opinions on motive or character, as the documented facts are considered self-explanatory. Harper continues his judicial duties without disruption to his court schedule or any public pronouncements from the bench. When questioned privately about his decision to formally escalate the matter, he offers a single, concise explanation. Because proper procedure safeguards everyone when it is adhered to. The relevant authorities respond by announcing a review of security protocols at all entry points to the courthouse. A directive is issued to all officers, emphasizing that decisions regarding access for court personnel must be based on verification, not on assumptions. The necessity of consulting with supervisors is underscored. The use of casual or inclusive language when referring to individuals is explicitly discouraged, with a preference for clearly defined entry criteria. Several weeks later, the internal investigation concludes. Officer Lewis is transferred to a role that does not involve overseeing courthouse access. He is mandated to undergo further training. The findings of the disciplinary proceedings are officially recorded. He is prohibited from independently imposing restrictions on access. This outcome is characterized not as a punitive measure, but as a necessary step for improvement. Subsequently, the civil litigation commences. Harper initiates a federal lawsuit alleging unlawful detainment, denial of entry, and a violation of civil rights committed under the guise of official authority. The lawsuit references the video evidence, the conclusions of the internal investigation, and the lack of any legal basis for the access prohibition. The compensation sought amounts to $14 million, intended to address not only the personal hardship endured, but also the systemic failures identified. The county acknowledges receipt of the lawsuit. There is no immediate refutation or public statement addressing the allegations. Discussions regarding a potential settlement are not made public. The legal proceedings advance through formal submissions, motions, and adherence to procedural deadlines, mirroring the very system that Harper has consistently upheld throughout his professional life. Media attention follows. Local news organizations report the established facts. National media outlets begin covering the story once the requested lawsuit amount is confirmed. Headlines highlight the disparity between assumed power and legitimate authority. The video footage is described factually, without embellishment. Commentators emphasize the critical importance of thorough verification and restraint in security-related roles. The public's reaction is measured yet resolute. Civil rights advocacy groups reference the case in broader dialogues concerning biases in access policies and the need for accountability. Courthouse personnel note a subtle but perceptible shift in the security atmosphere. Interactions become more considered, and the practice of verification becomes a standard procedure once again. Throughout this entire period, Harper maintains his composure. He declines to participate in interviews and does not seek a public apology. When asked by colleagues if the resolution feels like a personal triumph, he simply replies, "It feels like a correction." Months thereafter, a settlement is finalized. While the precise terms of the agreement are not publicly detailed, the financial settlement amount of $14 million becomes known. The county agrees to implement updated policies and enhanced training programs. No explicit admission of fault is made by the county, but this resolution brings the legal case to a close. The video evidence remains in archival storage. The official report is filed. The revised policies remain in effect, and the official record now accurately reflects the consequences of assuming authority rather than confirming it. It also documents the system's response once compelled to examine itself. If you believe that accountability should be applied universally, regardless of official position, please subscribe to receive similar narratives.